First of all, I'd like to thank Elena for that warm introduction, and working with Campania has been amazing. The staff, everybody here is great. I mean, I couldn't feel more appreciative to be a part of such an important institution in our community. And a lot of you as emerging leaders are going to have an opportunity to be parts of institutions like this. And there are things that everybody can do to prevent risk and to stop that phone call to me on the front end. And those are the sorts of things that Elena's asked me to talk to you about. And some of it's a little dry. It's interesting to me as a lawyer. I'm going to talk to you about the 10 most important federal laws that everybody who's a manager or an HR person or really just an employee with an eye towards leadership should be aware of. But before I get into that, it all starts with some pretty basic concepts. I'm sure that everyone's aware of that poem, All I Really Need to Know I Learned in Kindergarten. Is everyone aware of that? Well, a basic tenet of that is be fair. And as a leader, that's probably the most important thing I can tell all of you. Be fair. Be fair to people. And be fair in kindness and in discipline. You can't just not write somebody up because you're like, oh, well, Sally was having a bad day. But then you write Judy up later for the exact same thing, and you have a fairness imbalance. And that becomes a problem later when people start making claims under these federal laws that I'm going to talk to you about. So along those same lines, I can't stress this enough. Documentation, documentation, documentation. Mr. Van Velde said the same thing. Put it in the file. Whether it's good, bad, or ugly, put it in the file. And that's fair. I mean, treat other people like you'd want to be treated. If you've done something wrong, it should be documented. To that same end, if you've done something great, it should also be documented. And speak up when you see something that isn't right. I mean, that's kind of just a general human thing, but from a risk management standpoint for an employer, employees speaking up when something isn't right and leaders speaking up when something isn't right is very important. And if you feel like somebody's not listening to you, put it in writing and send it to somebody else. So now I'm going to start and I'm going to go into the 10 most important federal laws that every manager and HR person should know. The first one is Title VII of the Civil Rights Act. It'll often be referred to as just Title VII. That's how you'll see it. And it has to do with job discrimination. And it basically says that you can't discriminate against anybody based on their race, religion, sex, or national origin in any aspect of employment. I mean, that's hiring, firing, pay, placing a person in a specific office. It's everything that has to do, any tangible form of employment. You just can't treat people differently based on those things. And if you're fair on the front end, you prevent having a situation where it looks like that may have occurred, even if it didn't. Because I have to say, I deal with a lot of employment discrimination claims, and 99% of them, I know that my client didn't discriminate against somebody based on their race, religion, sex, or national origin, but it might be one of those situations where some people just weren't treated fairly. And so that can make it look like a Title VII claim. So no matter what anybody's characteristics are, ignore them, treat them fairly. That's the easiest way to deal with a Title VII type situation. And also, I want you guys to ask me any questions because this is intended to be a very broad overview, and I could talk about this stuff for days, but I don't want to put everybody to sleep. So the second law that'll come up a lot is the Fair Labor Standards Act, or the FLSA. And it basically says you have to pay people a minimum wage, and if they work over 40 hours, you have to pay them overtime. The federal minimum wage is $7.25. Indiana is the same. When this comes up for managers and people in HR is salaried employees, because salaried employees, if they meet certain exemptions, they're not subject to the Fair Labor Standards Act, which means you don't have to pay them overtime. So an issue comes up when you change the duties that somebody does. You change the way that they perform their job. Well, that could take them out of that exemption and they could potentially be entitled to overtime. So as a manager or a new leader, and if you're responsible for employees and you're changing their job responsibilities, you need to contact someone in HR and let them know about that. The third law is the Family and Medical Leave Act, or the FMLA. And the Family and Medical Leave Act basically says that eligible employees, or people who have been somewhere for more than a year, are eligible to up to 12 weeks of unpaid leave. And that can be for the birth of a child, for adoption of a child, to care for themselves, or a sick child, or a spouse, or a parent. The tricky thing when it comes to FMLA leave is that an employee doesn't specifically have to request FMLA leave. So as the manager or the HR person who's receiving a request for leave, you need to listen for things that would spark FMLA compliance. So things like that, birth of a child, adoption, or caring for somebody. And you also want to be careful not to really ask too much, because you have to respect people's privacy rights when it comes to their disabilities. The fourth law is the Age Discrimination in Employment Act, and you'll hear this one referred to as the ADEA. And it basically says that you can't discriminate against people who are over 40 years old because of their age. So a way that new managers and supervisors and HR people can deal with the ADEA is to never take a person's age into account when you're making employment decisions. This comes up a lot when companies want to reduce their force. And it seems like a good idea, well, maybe we should, reduce the force to these employees who will be retiring soon. Well, you can't do that because that's illegal. And in that same regard, when you decide who you're going to bring back, if there's been a layoff, you can't just bring back the younger workers. So those are things to be aware of and ways to avoid ADA claims. The fifth law is the Americans with Disabilities Act, and that's the ADA. That prohibits discrimination against people with disabilities. And that's very tricky because the ADA has recently been amended, and it could be even somebody who's just perceived to have a disability. The disability doesn't even actually have to exist. So what you have to do with somebody who is disabled or is perceived to be disabled is an employer needs to provide an employee with reasonable accommodations. And that's basically anything that would help the employee do their job, that wouldn't be an undue burden on the employer. And as far as courts are concerned, it's a pretty hefty burden to show that it's going to be an undue burden. So this kind of goes back to the theme, which is fairness. Treat people fair. Try to work with people. People, for the most part, are reasonable if you're open and honest and fair with them, and you can probably reach some kind of agreement on how we can work with this person's disability. The sixth law is the Uniformed Services Employment and Reemployment Rights Act, or the USERRA. And it basically makes it illegal to discriminate against employees who volunteer or are called to military duty. And I mean, it makes sense. You want to give people that serve our country, if they leave, you want to give them their jobs back. And military personnel tend to make really great employees anyway. A thing that comes up a lot in this aspect is you don't want to challenge a returning reservist bid to get his old jobs back. Courts almost always side with the reservists. So you need to either reinstate them to the position they originally held or give them an equal position. The seventh, that's the Equal Pay Act, and we're in a room of women, and that law, the EPA, says that employers can't pay female employees less than male employees for equal work on jobs that require the same skill, effort, and responsibility. The way that this can take place, and if you're a manager or an HR person and you're dealing with an issue like this, you can pay people different wages if it's based on criteria that's not just based on gender. So, for instance, somebody's education or training or experience, what would make more sense that you should be able to pay that person more. So, to avoid these types of claims, it's a really good idea for an employer to periodically look at their pay scales and kind of see and make sure that, okay, well, we're paying people with the same skills the same amount of money, just so you don't have these disparate amounts of money that you're not going to be able to explain when the case gets to me. Okay, the 8th law is the Occupational Safety and Health Act, and that's OSHA. And OSHA basically says that employers have to maintain a safe work environment for their employees. So what employers can do, and what you as managers, emerging leaders, or basically anybody, is if you see something that's dangerous, you should report it. Or you see something that will cause a hazard, you need to let somebody know. We see a lot in this aspect. They're called whistleblower claims, and it's when an employee claims that they've seen something that's not safe and they report it, and then something later happens and the employee is either disciplined or terminated. That can be a whistleblower claim under OSHA, because they can say the employer retaliated against them for reporting that, for that safety violation. The 9th law is the Pregnancy Discrimination Act, and that basically says that you can't discriminate against somebody because they're pregnant. What I counsel people on when I counsel them on the Pregnancy Discrimination Act is kind of treat it similar to how you would treat an ADA claim. You can't discriminate against people because they're pregnant. So, for instance, if you provide light-duty work for somebody who's injured or somebody who's disabled, well, you need to provide that same accommodation to somebody who's pregnant. You just can't treat pregnant people different. The only reason you could do it is if it interfered with the job that they had to perform. And all of these laws boil down to a reasonableness standpoint. So if you're ever confused, obviously you go to your HR person, or you go to an attorney and you ask. But for the most part, reasonableness and fairness is the key. The final law I want to talk to you guys about is the Immigration Reform and Control Act, or the IRCA. And it makes it illegal to hire and employ illegal aliens. Employers are required to complete I-9 forms to show that people are not illegal aliens. But things that people aren't always aware of is that it's also illegal to discriminate against illegal aliens, even if they were hired inadvertently. So illegal aliens can make discrimination claims or Section 1981 claims against employers, even though they shouldn't have been hired in the first place. And the final thing, and this applies to all of these laws that I just went over, are retaliation claims. So if another employee reports one of these things, or if somebody files a charge, or if somebody files a lawsuit, an employer can't take any adverse action against somebody who has complained or filed or participated in an investigation, because that also opens up the employer to a retaliation charge, which are just as serious as all of these other charges. So that's a brief overview, and it's a lot for new people to handle. But it's just good if you're aware generally of these types of things, then it'll help you be a better leader, because you'll see things. And it goes back to what I was saying in the beginning. Speak up when something doesn't seem right. That's the biggest preventer of liability for an employer, is having employees that notice things and say something about it. And I want to open it back up to questions, but I wanted to address a question that you asked earlier. You asked the previous presenter, Mr. Vanderveld, what do you do if you don't necessarily feel like you have innate leadership skills, but you think that you want to be a leader one day? And what I want to tell you is that it comes with time. Nobody walks out of the gate and is completely confident. It's like, oh, I can definitely lead all these people. That's just, I mean, that's ego if that's what you have. I want to tell you, when I was a new associate, I was so scared, and things would happen, and I'm like, oh my gosh, how am I ever going to be able to do what my boss does? And it seems so far away. But I'll let you know with time, and you pay attention, and one day it just clicks. It really does. And one day you just wake up and you're like, oh, I'm not scared of that anymore. I can handle that. I can be a good leader. And that'll happen for you too. Does anybody have some questions for me? I know I speak fast, so.
Could you
I
explain
have a
the Title
question
VII
for you.
claim again?
Oh, sure. Yeah, absolutely. Okay, Title VII, you cannot change the terms and conditions of somebody's job. Anything about the aspects of somebody's employment based on their race, religion, sex, or national origin. So you can't discriminate against people because they're different from you. And so that can be a myriad of things. And the Seventh Circuit basically also just recently said that applies to sexual orientation too. So it says, I can't take privileges or pay away from Sally because she's different from me, or because she wears, you know, a headpiece, or anything that you think customarily is different from you. You cannot treat people differently and punish them in employment because of that. Does that make sense?
Completely.
Okay. Yes?
So, when you have an employee out on FMLA, and then they can't come back after the 12 weeks, how do you determine if the ADA covers that person or not?
Well, that is a really good question, and that's coming from Compania's HR department. So, the thing is, and that is a tricky situation, because it could fall, that person could be considered disabled at that point. And is indeterminate unpaid leave a reasonable accommodation? That's possible. I mean, it's a balance between, you know, the needs of the organization and whether the person, I mean, is not being able to return to work, fulfilling the essential functions of the job? Probably not. But it depends on the hardship to the employer. I mean, and that is a very sensitive case that could potentially wind up in litigation. I mean, and you counsel employers, I mean, I counsel my employer clients about those things. And I basically say, you know, there's an argument that this person could make that indeterminate unpaid leave is a reasonable accommodation based on my disability. And as the employer, I would say, well, we can't be expected to hold your position open for an indefinite amount of time, because we have to fill it and we need people here. I mean, and I know at least at Compania, you have ratios that you have to fulfill to meet state guidelines. So that would be another factor on the balance. But that's a very good question without a clear answer.
Yeah. I have
Yes.
a question. So oftentimes we promote from within, and that's obviously what we prefer to do. So we have director staff that are promoted into supervisory positions, and usually that's the first time that they are in a leadership position or a supervisory position. So what advice do you have for those people? Because now they need to create healthy boundaries, right? And it's very hard, because before you were friends with people that now you're supervising. And you're the bad guy if now you're not going to go out and have drinks after work. And so what advice do you have for them? And one of the things we do see a lot coming from that is that when you're not able to do that successfully, favoritism is something that comes often to human resources and says, you know, those two are buddies, they hang out. And, you know, for those new supervisors in those roles, it's difficult. So what advice do you have for them to be able to create those healthy boundaries and be aware of those favoritism issues that may come arise?
And you're exactly right. I mean, I see claims based on that, and that's a big problem for people, especially first-time people in leadership positions. And the advice I would give is you have to be a professional. You have to ascend, and hopefully your friends will understand that, but sometimes they don't. And that creates a lot of pressure for you to give them favoritism, but you absolutely cannot. You have to treat everybody the same. And what it comes down to is whether you're cut out to ascend to that higher role, or whether you still want to be there and be buddies with your friend. It's a maturity thing. And anybody who's your real friend would understand that, is what I would tell new promotees. And you cannot play favorites. You absolutely cannot. That's the biggest thing that all managers need to know, is you just need to be fair to everybody, whether you like them or not, whether they're different from you or not, whether they are weird, it doesn't matter. Even whether, you know, and then that's another thing, being honest on employee reviews, that's a huge thing that I see that causes a major problem. I get these calls and they're, so-and-so was the worst employee we've ever had, and they were always causing problems. And then you get this pile of 10 years of reviews and they're glowing. You know, well, who was filling out these reviews? Because it's human nature to want to be kind to people, and you absolutely should be kind to people. But part of that is being fair and being honest with people. Being straightforward is much better than trying to clean something up later. And I'll tell you what, in my own experience, I've had issues like that with my own assistant, and I've gone to her and I said, look, these are the things that I think we should work on. And she was grateful for it because I was honest about it, and I didn't wait till her review and then she reads it and she has no idea what's going on. In that same regard, another thing I will caution you on as new leaders and when you're promoted into new positions, don't do anything out of anger. Nobody's ever made a good decision when they're mad. I'm a litigator, so I get hundreds of emails, a day, on a busy day. And I've been upset before, and what I do is I write an email and I let it sit there and I come back to it the next day. And it's rare that I still send that same email. So I think in this day and age with how fast technology is, I would recommend that. And in that same regard, when you get mad at somebody, because you will get mad at people, because people do crazy things. And you just, in your mind, in the moment, you're like, how could you do that? I take a step back, I go collect myself, and then I come back later and I say, well, I'd really like to talk to you about what happened earlier. Don't speak out of anger, and don't do things out of anger because you'll regret it. Does anybody have any more questions? Yes?
With the ADA, and you said now it included in that is a perceived discrimination, perceived by whom? The person? The
employer?
Or I think Mary has something.
No, like if the employer perceives that somebody has a disability, say Jody's missing work all the time, and others, oh well, maybe Jody has X condition. Well, that's something that could be a perceived disability. So if we take an action against her based on what we perceive as a disability, that would be considered illegal activity. Yes?
In addition, excuse me, in addition to the ADA, what she was saying, the question, I wanted to ask, I've been recently just applying for jobs, and it's just like occurred to me that one of the questions on these applications is, are you disabled? And then it has like a list of things.
That shouldn't be on the application. What kind of job is it though?
But it is though. It is on a lot of them.
Is it a job that requires physical ability?
Well, yes and no, I guess. They're like supervisory positions or home-based casework or it's to me doesn't require a lot of.
The only time a disability would be relevant is if it impacts your ability to perform the job.
Okay.
So, for instance, like a fireman that is a quadriplegic, that would be relevant because it could not perform the essential functions of the job. But if you're just applying for a supervisory role, I don't know that is a legitimate question. And
if you go on it, maybe you can do it tonight. Like just go on there just do some stuff. But you'll see it. Like every application I've done.
There may even be a thing where it says that it's optional to answer.
It's not though.
Okay.
It actually says that it's for the disability. It's not optional. You have to say yes or no. And for the race, you have the option of saying I prefer not to answer. But for disability,
I'm surprised by that.
Yeah, because I was just like,
depending on the size of the employer, I would probably expect a challenge to that by the EEOC at some point.
Yeah, it was really weird, but it was for a lot of places. Some nursing homes, nursing facilities.
So that's another thing. So that didn't sit right with you.
Yeah, and I was
so
like,
you should say something to the employer about it.
Because when you see this list of disabilities that you can have, it can be HIV, it can be needing a wheelchair, it can be maybe just some little stuff.
Are they asking you if you have those specific disabilities?
Yeah, it's like a list.
Okay, so I would suspect that the list of specific disabilities they listed has to do with the essential functions of whatever that job would be. Because, like, for instance, you mentioned a wheelchair. Well, you wouldn't be able to care for indigent patients if you were in a wheelchair. And in that same regard, it's probably important not to have people that might have contagious disease around infirm individuals.
Yeah, but it was just really weird because you can't catch HIV. You
Sure,
can't catch it if I cough or something.
I understand that, but if you're around knives or sharp,
Yeah, so it was just really weird. And I was just like, really?
Well, you can ask about it if you're not comfortable answering.
Yeah. Oh no, but it was fine. But it just was weird because it was like you had to make a choice, and
Sure.
the other section was like, I prefer not to answer. It was really weird. Yeah.
I agree with you.
Yeah.
Does anybody else have any questions? Okay, thank you.
Other than like the documentation, because you said like document everything, as
Mhm.
far as any type of discrimination, how can you prove that other than your documentation?
How can you prove,
How can it be proven without,
how can you
other
prove?
than documentation?
It's difficult because the way things are proven without documentation is just word of mouth. So the people involved would provide testimony through deposition or interrogatories or other ways. But the documents, because they're created at the time that the incident occurs, it's always more reliable from an evidentiary standpoint, in my opinion and in the opinion of most courts.
I mean, should everything be like electronic or journal keeping?
Electronic is good, but a way that you can provide a copy of it at some point later. So if somebody reports something to you, it's a good idea that you record it in some written form and then send it to the appropriate person. Or in that same regard, if you're reporting it, I would suggest if you are ever reporting any of these issues, report them in writing.
Another question for you too. Where does like harassment fall in line?
Harassment?
Yes.
Harassment falls under Title VII, and there's all kinds of harassment that are prohibited. I mean, you can't, sexual harassment falls into that because that's discrimination based on sex. So, and the same as if somebody is harassing somebody for their race or ethnicity or sexual orientation. So that's a good question that falls under Title VII.
But it doesn't have to not necessarily be against their race or
Well,
national origin or
It does. It has to be against one of those protected activities. Can you think of an instance where it wasn't?
Well, in sort of a case where somebody is like bothering somebody on the job, sort of like bullying, you know what I mean? So it doesn't, I don't think that has anything to do with like race or anything like that.
So if it doesn't, then that's not necessarily illegal. It's wrong, and your employer probably has an employer probably would have a policy that covers that because it's just not fair to treat people like that. And there's probably something in the personnel handbook that would prevent that. Like everybody needs to act like a professional or a code of conduct type thing. But if it wasn't based on race, religion, sex, national origin, it wouldn't be covered under Title VII.
Kim, what about creating a hostile work environment, though? Would that fall under something like that?
It sure does. It falls under Title VII, and that is usually a hostile work environment is sexual harassment, and it's when the harassment has gotten so severe and pervasive that it interferes with your ability to perform your job. So that's somebody that just keeps harassing and keeps harassing. And what happens is, in a lot of instances, is the person that's being harassed will quit. And they can make what's called a constructive discharge claim. And it says, you've made my work environment so horrible that a normal person, a reasonable person, wouldn't be able to tolerate this activity. So I was constructively discharged. And what employers need to keep in mind and supervisors need to keep in mind is it doesn't have to be somebody in authority doing that. It can be a coworker. It can even be a maintenance person or an independent contractor that you hire to come on the property. It can be a client. Employers have an obligation to protect their employees from these sorts of things.
How would you prove that as well? How would you prove constructive discharge?
Well, that is a question of fact, but you would show that, for X amount of months and every day this happened. I mean, it's generally, you see complaints that are 100 pages long, and it's like, on this date, he called me cute. On this date, he started texting my phone. On this date, he said I should do this and I could have a promotion. And then when I denied his advances, things started to get worse. So it's over a period of time, and they're generally fact-based allegations. But if things like that happen to you, or you see things like that happening to other people, that's when you need to speak up because something is not right, and you put it in writing and you send it to the employer. And almost all employers have a procedure and protocol for reporting things like that. But what happens is a lot of times younger women, they want to keep their jobs and they don't speak up. So I mean, and you rely on people around you. So if you see it happen to someone else, you should also speak up. Yes?
You mentioned that it could be sexual harassment, you know, a client could be doing it to the employee. How is something like that handled?
Well, an employer would have an obligation to remove the employee from that situation.
Okay.
So, I mean, and sometimes it's not necessarily always fair to the employee, but the employer has an obligation to remove an employee from that type of situation. So you might be transferred to another department, or you would maybe not work with that client. For instance, if it's a subcontractor or a maintenance person that comes in, maybe the employer doesn't utilize their services anymore. Yes?
A question that often comes from new supervisors, and they're very frustrated, is that they have excessive, or what they refer to excessive, calling off of employees, just not showing up for work or getting sick at least once a week. At what point would you say that it would be excessive excessive call-ups for them to actually be able to take action and do something about that employee?
Well, I think the best course of action for that is to have a policy in place that has to do with excessive call-offs. And I think most places have a certain amount of PTO that employees can take. But I would make sure to have it in the policy, and every time it happens, you would write that employee up and you would counsel them and you would say, look, you've called off on this date, this is our policy. You know, the next time it occurs within this amount of time, you know, it's going to happen again. And you keep it like that, because you also have to be very careful, because maybe that employee is missing for doctor's appointments and maybe it becomes an ADA issue. So it's a very delicate balance. But if you're disciplining them under the policy, then that's separate and apart. But then when they come to you and they start saying things like, you know, it was bringing you doctor's notes, then it becomes a different issue.
And I think sometimes they do run into situations where the employee is often sick, or there's multiple deaths in the family, so they're excused time offs. So that is something that new supervisors often struggle with, because there is some excessive use of paid time off, and
Sure.
they don't know at what point do we start taking action and documenting, because the employee has an excuse every time.
And maybe the solution is to revise the policy that whether excused or unexcused, it comes under a written warning or discipline if it's becoming a systemic problem.
So to piggyback on that.
Sure.
So you have somebody who's calling off excessively, and how do you go about finding out if there's a particular reason? I mean, how much prying can you do
That's
for this person?
Another great question from the HR manager. So what you do is, it depends. It's delicate and it's a balance. And you see, are they bringing you doctor's notes? Well, if they're bringing you doctor's notes, then there is a time when you can start inquiring. If they're not bringing you doctor's notes, you start writing them up, and then it's on them to bring it to you. But there's a point where you can engage in the interactive process and say, look, it's always a business decision and a cost-benefit analysis how you want to handle it. But you say, do you need some sort of accommodation? We've noticed that you're calling in X amount of times a month. When you signed up for employment, you were expected to be here X amount of days. Another thing you can do is, when it comes time for their evaluations to come around, you can say, look, this is exactly what we expect of you. We expect you to be here X amount of hours a week, and I know that you've only been here this many hours a week on average. Well, this is a problem for us. And maybe it's at that point that it's kind of on the employee to speak up and say, well, I'm having this issue. And I don't know that I would advise an employer to go that far unless they have been presented with doctor's notes, or some sparking thing from the employee basically saying that I have something wrong, like a medical issue. Does that make sense?
Mm-hmm.
I know it's gray. You ask the gray questions.
Always.
So if an employee, like our policy is on day 3, if they've called off on the 3rd day, they have to have a doctor's note when they come back. So I think what happens a lot is they'll call off 2 days, and then 3 weeks later, call off another 2 days. We can't really, ask them for a doctor's note if that because policy is,
Exactly, you have to go by your policy and maybe you
and
need to
so,
change your policy.
you know, then you run into, well, are
Which
they?
I can help with.
Well, I don't know. Yeah, it might, because it makes it hard. There's many people who are sick for 2 days only. And they can be sick, you know, a couple times a month for 2 days only. And, you know, then others who have, you know, their work, I mean, then it just creates discord in the department too, because they're like, well, you know, nothing ever happens to so-and-so, and they call off all the time. But yet, there's not a lot, I mean, I feel like our hands get tied a little as far as what you can do.
And sure, and that kind of goes back to what I was explaining to Mary. You can present that employee with, you know, evaluation and say, look, we have these set expectations for you. And it seems like clockwork, you're missing 2 days a month. And, you know, what's going on here? We expect you to be here. And then it's on the employee to maybe say something. But if you don't have any indication that they have a disability or a medical condition, there's not a reason why you can't expect somebody to perform. In my opinion, it's an essential function of your job to show up at your job.
Right.
So, I mean, and there's some plaintiff lawyers out there that would have a different opinion of that, but. Does anybody else have any questions just from a general leadership standpoint, or? You guys are lucky to be taught by Elena. I haven't known her for that long either, but she's very impressive to me, and this organization is extremely impressive to me. And it's very important to this community. And we're lucky to have somebody like Elena at the helm of it. Thank you, everybody.
Thank you.